Well, good morning and welcome, everyone. I'm Tim Fisher, Dean at the University of Connecticut School of Law here, and we are really thrilled you're all here. And we're especially thrilled it's not earlier in this month with one of our interminable snow days of this year. It's so much better now. So this is a really exciting program for us because it is, we believe, the first academic conference of its nature studying the area of litigation risk. And we are thrilled to be part of that and to be the host of that, especially because our Insurance Law Center is the leading collection of scholars and courses and students in the world on the assessment and the financial assessment and the mathematical assessment of risk. And we are now making this move into recognizing a new frontier in the field of managing risk and calculating the odds on risk. And so we're really thrilled that this conference is a kickoff to that entire effort of a new area of exploration. This event is also exciting because of the incredible cross-section of participants that are here today, both among you in the audience and among our panelists, between folks focusing on theory versus the applied nature of this field, between plaintiff orientation and defendants, between funders and insurers, between trial lawyers and systems managers, and all those perspectives together being exchanged, we think really heighten what we're able to learn and gather from each other. There are a number of people who were really crucial in making this conference a reality here today. Our director and deputy director of the Insurance Law Center, Professors Brendan Maher and Peter Kotchenberger, our communications director, Jean LeBlanc, our events manager, Deb King, who had all the logistics in hand and made them work, and Pat Carberry. Now, Pat Carberry I have to identify especially because if any of you parked on campus, please give your license plate number to Pat before you get ticketed. We really don't want you to get ticketed, and we could take care of that if you get that to Pat beforehand. The students you've seen around us today are the students from the Insurance Law Journal, which we're tremendously proud of, and then especially our Ellen Ash Peters Professor of Law, Alexandra Lahav, who conceived of and organized this conference and really has given us a magnificent program here today. And so with that, it's my pleasure now to turn the first phase of this program over to my good buddy, former partner, Bill Narwald, member of the class of 1979 here at UConn Law School. Bill clerked for federal judge Warren Edgington. Then he was at the law firm of Cummings and Lockwood for a couple of decades. He was managing partner there. And then where he was managing a huge array of very complex litigation, largely for corporate clients. And then in 2003, moved over to Motley Rice, which is one of the largest plaintiffs' law firms in the country, a major player in the fields of tobacco litigation and others. Bill works in their key TAM group with whistleblower cases and class actions in areas such as opioids and terrorist financing claims. And the students in my course on case studies and compliance systems were especially fortunate a few weeks ago that Bill came and talked to them about that incredibly vibrant area. And also tremendously helpful to us because his firm, operating at the level it does, has a very sophisticated understanding of how it assesses litigation risk. And so with that, it's my pleasure to turn the program over to Bill.
Good morning. Thank you, Tim, for reading that just as I wrote it. So our topic this morning is current methods of evaluating litigation risk. What is it? How is it evaluated? What works and what doesn't? We are told that we have to stay on a strict time clock, so rather than give you lengthy introductions of my three co-panelists here, just to quickly go through, their bios are in the materials, but let me just give you a quick introduction here. Right to my left is Selvin Seidel. Selvin and I have actually known each other for almost 10 years now, and Selvin really started the litigation finance business. He's going to talk a little bit about that and some of the work they're doing. Liz Saxeter, who is currently a partner at Paul Weiss, headed up global litigation at Citigroup, and before that headed up litigation at the Hartford. And her successor in that position at the Hartford, Jim Hevner, who currently manages all litigation at the Hartford. So I think we've got a pretty good cross-section of people to talk about litigation and litigation risk. What we would like to do is we're going to lead off with Selvin, and Selvin's going to give you a perspective of, from the litigation finance perspective, about how they look at risk. I really actually have the easiest job here because I refer to myself as the skunk at the picnic. It's my job as a plaintiff's lawyer, as a class action and mass tort lawyer, to create risk for probably most of you who are sitting out there. And what I've got to do is hope that you misprice it to the upside. And so my job's pretty easy. I don't really have to sit here and quantify it. I don't have to do financial statements and accruals. I don't have to go and talk to the board about why it is that this crazy plaintiff's lawyer is challenging the company. I just have to create the risk. So it's really the rest of the group that has the laboring oar here this morning. So quickly on Selvin, he has been described as the George Washington of litigation finance. Does that mean you were first or very old? I'm not sure which.
Very old.
So litigation to the funders is what they call a non-correlated asset in an inefficient market. And so I look at litigation funders a little bit like investment bankers. They look at litigation strictly as an asset. They look at how do I make money on that non-correlated asset. They focus on outcome risk and they focus on ROI. So with that, Selvin, I know you've got a little bit of a presentation. If you can give us a sense from your perspective, and you were also obviously in private practice for many years, but from the perspective of a funder, looking at either a piece of litigation or a portfolio of litigation, how do you come at it from a risk perspective? How do you look at that?
Thank you, Bill. And as you can see, we've got a tough taskmaster here. I have approximately 8 minutes to talk with you and to...
Exactly 8 minutes, by the way.
Yeah. And now 7 minutes and 50 seconds. This is what I have to deal with. So the way I've done this is I've prepared some writings that you can pick up if you're interested in this area. There's an outline plus a statement that I've put together with my co-author, Fred Kipperman, and you'll get a better idea. And that way they can't stifle my presentation. A quick introduction. First of all, you are, just by your numbers, you're a pioneering group because this law school through Alexandra is very much, and Tim, is very much at the lead in this area of measuring litigation risk and measuring litigation finance risk, which is different. So you're lucky to be in at the ground floor. That's when this is really taking off because it's been neglected for years and years, and it's been untouched in the litigation finance risk area. Now, what is litigation finance risk? Most of you may say, I couldn't know less about it because it's still getting to be known in the country, which is the leading country for it, along with the UK and Australia, of all places. And it is going to continue to be an overwhelming force in litigation. What is it? Well, basically, it's nothing more than a third party coming in and saying, this is a good litigation, I'm going to bet on it. The industry hates the word bet, but that's really what they're doing. They are wagering on a good litigation that if they pay for the litigation costs, the lawyers and the experts and so on, they're going to be able to recover. The claim is going to succeed and they'll take a share of it. It's very much comparable to contingency law work, but here you give the money to the claimant, and it's usually in the range of $1 to $10 million, to hire their own law firms and pay them, and hopefully succeed because otherwise they didn't have the money to prosecute it. Now, that is a very simple description of it. It's much more complicated, as you'll find from reading this text, but it's the essence of it. Now, what happens when such an industry starts? And it really started in the U.S., as I've explained it to you, only in 2009, 2007, about 10 years ago. But the U.S., which has so much litigation, has become a centerpiece. Certain states and cities in the U.S., New York, of course, Chicago, Los Angeles, San Francisco, there are certain hubs of litigation financing where most cases come from. And what it's done is it's revolutionized, I think, and the media is starting to confirm this. It's revolutionized litigation because you have more people who are able to, if it's a good case, be able to prosecute it, even though it is even though they don't have a nickel to. In fact, sometimes because the defendant had killed their nickel. So this industry is getting a huge following across the country, across the world. There are a number of countries that are just getting into it, like India, like Hong Kong, like Singapore. So you're going to see it, and it's going to go on for a long, long time. What it claims that it's basically delivering justice, civil justice, because it's giving someone a voice that otherwise wouldn't have had it. The fact is, they also say, the industry says, that we're giving commercial justice as well as civil justice because this is what the claimants should be receiving. And by the way, we'll get our own profit, and a very hefty one, out of putting our money up, because we'll get back an IRR of 30, 40, 50%. And since the investments are usually between $1 and $10 million, we'll make a lot of money. We'll double our money, we'll triple our money within a couple of years. So it's very, very profitable if you do it right. The opponents, and this industry has a huge number of opponents. It's very controversial. The Chamber of Commerce, the U.S. Chamber of Commerce, is who represents basically defendants, has taken the biggest stance against it. And they say, there's a lot of things they say about it, but they say one thing that's a big problem is you charge way too much. And you take advantage of vulnerable claimants. So it's unconscionable what you're doing. The industry comes back and says, well, you know, the claimants are sensible, they're commercial, they're not consumers, they're not helpless, they understand the risks and they want to recover on it. They'd lose otherwise their entire investment. So it's a very sticky sort of dispute, which is still going on. I think, because I'm biased, that the industry is winning because it's gaining use and popularity throughout the world. However, how do you really decide whether a case is a good case or a bad case? Is it a meritorious claim? And there you have to study the risk in winning or losing the litigation. But in addition, you have to study not only whether you're going to win or lose, but whether it's worth financing, because there are different risks when you finance something than just the litigation risk. You're going to hear mostly about litigation risk today. We take that risk as a given because we're brought the case usually through good law firms who've done their own case analysis and have studied it and say, this has got a 60% or an 80% chance of winning, and we have to take their word for it. But We also verify it. We'll do our own analysis. We will look at the risk in a secondary basis, not with the thorough deep dive, but we'll look at it by bringing in our own experts like Mark, who you'll hear later on today. He's a litigation tree analyst, and he's a wizard, probably the best in the country. And we will ask him, you tell us what you think about this litigation risk. Or we'll bring in our own litigation law firm to do a quick look at it. From there, if we satisfy ourselves that the litigation is a good risk to invest in, we will then bring to it the analysis that you need to do as an investor. And there, it's very much like what a private equity house or a venture capitalist or a hedge fund will do, but the asset is different because the asset is a commercial claim. People have a trouble, understandable, in wrapping their head around that notion that a commercial claim is very similar to another asset, such as a business, which you ordinarily buy and sell. Well, you appraise what the business is going to do in the future. So what we do is we will bring to it a whole bunch of analyses. That's the traditional analyses, using e-discovery type of things, or big data, which are traditional. Plus, we're doing much more in terms of analyzing it through uses of psychology, neurology, brain theory, game theory. So behavior analysis, and we're analyzing the judge or the arbitrators to come to some decision about whether this is a good opportunity, a good risk or not as an investor. We'll look at it through a whole bunch of things, and the biggest enemy of what we're doing is the lack of information in the industry. The industry is new, it's changing every day, it's very complex, it's hard to understand. So the investors who have come into the industry, maybe 25 or 30 institutional investors worldwide, not many, but now you're having investors who say, well, if you can give me a sophisticated analysis of risk, I'll put my money into it. So you have Fortress, a private equity house, which is publicly pledged $500 million to invest in this industry, and so on.
I'm going to stop you
Yeah.
there, but I'm going to ask you a question. Your business and my business is not dissimilar. We use our own capital. We make investment decisions. But our process, our risk analysis process, is still experiential. That is, we say, can the defendant bear a judgment of a certain size, ability to pay? What's the jurisdiction? Who is the judge? What are the merits? I mean, but it's an experiential judgment that we make. And we turn away, probably like you, 95% of what we see. Is there anything that you used at either Burford when you were there, or anything that you use at Fulbrook that is, whether it's proprietary software programs, whether it's data analytics, are there more sophisticated tools than experienced lawyers looking at a case and saying, yeah, that looks like a good idea?
Yes. The answer is that while we're in the same sort of business as some contingency firms, some very good ones like Motley Rice, we evaluate a case, I think, further and with a different eye. We take their view of whether it's a good case, and then we double check whether it's a good investment. And we'll look at what investors look at. We'll look at derivative. We'll look at safety nets. We'll look at the law of probabilities. We'll look at hedging. We'll look at cap bond analysis, which is big analysis for catastrophic risks. And we will then say whether we think this is a good risk. Now, how do we do it? We still we still rely very much on human judgment. You're never going to replace it. Experience in the industry and reviewing cases is irreplaceable. You're never going to find that it's going to be taken off the.
Let me stop there because I want to make sure we get Liz and Jim involved here. So Jim, let me turn to you. You were in private practice for a number of years in D.C. with some national firms. The last 15 years, you've headed up litigation at the Hartford. I'm guessing, although I don't know this, that you probably, or someone at the Hartford probably knows to the second decimal point what a personal injury case is worth and what it costs to defend those cases. I heard the other day that Allstate has something called Colossus, where they put all this data in and it comes out with a number for at least repetitive litigation. But I want to kind of move to a kind of a different spot, which is Selvin has talked about from a funding perspective, looking at a piece of litigation as an investment, as an asset. Obviously, there are different concerns when you're advising a company, and you've got both direct litigation against the company, and you've got litigation against your insureds, and those may have different issues to them. But I guess what I would like to hear from you and from the Hartford is, what kinds of things do you use internally to quantify risk, to look at litigation risk? And what are some of the other kinds of risks that you have to look at beyond just financial risk? That is reputational risk, precedent risk, portfolio risk, those kinds of things. So,
Okay, Bill. Compound question.
Yeah.
And
you have 8 minutes too.
I'll backpedal for a little while and answer a different question, and then I'll answer part of your question. First of all, I want to comment on Selwyn's comment about machines not replacing humans in this space. I think that's generally true. I'm not a person who thinks that human judgment, lawyer judgment, will ever be eliminated entirely, but I do think there are lots of things that we as lawyers do that could be done perhaps better by a machine. So when a litigation financer is evaluating the worth of a particular piece of litigation, and are relying heavily on a lawyer's or an expert's judgment on that thing. That expert, in part, is just doing a probability assessment around what the outcome of the case is going to be, right? And there are risk factors that are employed. But they might be called risk factors. They're drivers. Every case will have 1, 2, 3, 4, 5, 10 potential drivers, probably a handful that ultimately prove to be the thing that drives the outcome in the matter. An example, I might posit, to take a really simple case, personal injury case, very basic. I might posit as a lawyer, based on my experience, that in certain jurisdictions, the only thing that's going to matter to the outcome of that case are some specific attributes of the plaintiff, a very sympathetic plaintiff situation that I can very quickly determine with a pretty high degree of probability based on that one factor what the range of outcomes in that case is going to be. I'll posit that as my thing. But again, that is based on my experience and the experience of my colleagues and experiences that I've read about. The knowledge I have is incomplete, and it's quite possible that I'm drawing causal connections between the fact of the plaintiff characteristics and the outcome in ways that aren't right? With a more complete data set, it might turn out that one judge in that jurisdiction never lets cases of my type get to the jury. So I've just ruled, my major factor has just been effectively ruled out of the case. It might be that certain types of defendants in that jurisdiction fare much better than other types of defendants, whether it's by line of business or whether it's by reputation or any number of factors. I might or might not know that based on that jurisdiction, but there's data out there that I could use if I had the data that would assist me in refining for a particular matter, what the outcome might be. I think there's a real place for substantial more work in just a single case litigation assessment in that front. But I'll move to another piece of your question, or at least a piece of your question now, which is the predicted outcome of one case, at least from the perspective of a corporate defendant, is if you stop there, you're just stopping at the water's edge, and you're not doing a complete analysis of the litigation risk. Just one potential factor that comes into play, for example, is precedential risk, which also can lead to a need to change business practices based upon the outcome of a case. Those costs are both tangible and can be quite large. As you may or may not know, companies today, by and large, have gravitated to a desirable mode of operating and their operations very consistent practices, right? It's an assembly line type concept, which is cheaper, allows you to be more cost competitive, to make more profits, and provide a more consistent experience to customers, which, if the experience is good, is a beneficial thing for the company, right? What that also does is means if you've made a mistake in the application, in how you apply your processes in one instance, there's a much larger chance that that mistake is being replicated over and over and over and over and over again, which means potentially more litigation beyond that case, lower probability of success if a bad outcome has arisen in that first case, and the need to change your business practices, which, as I say, can be extraordinarily expensive in today's world. There are real financial costs that have to be taken into account in evaluating what you would be willing to pay to resolve a particular case. That lie well beyond the facts of the specific case. As you guys know, most cases don't go to a jury ultimately, and a large percentage of those that don't get settled. And settlement outcomes are often hard data sets to get a hold of, but to the extent you have them, can be informative if you understand how and why the settlement ended the way that it ended. Before I move on, I would also know that settlements also have a bit of a precedential, can have something like a precedential effect, right? You might have cases in which you're willing to pay what I'll call the face value, the estimated value of the case, or even overpay, because the case has attributes that aren't desirable for getting a good ruling, a good outcome, that go beyond the main issue that's in play, or you're in a bad jurisdiction, you have a judge that doesn't like you, whatever the case may be, and you'd rather look to defend an issue that's going to come up across your book in a place or on facts that provide a better platform. It may also be that even with respect to a case that's both sides value essentially the same way, but you have a disagreement over whether the process is a good one or a bad one. When you take into account the cost of having to pay this plaintiff a fair price and every other plaintiff that comes after that a fair price, and or change the cost of changing your practices so that you don't have plaintiff after plaintiff after plaintiff after. You might well decide that whatever the risks are in establishing and getting a bad ruling on the practice, they're really no worse than taking your shot.
Well, let me ask you on that. So, I mean, you've identified a variety of scenarios in which you bring different judgments to bear. And so I want to ask you the same question I asked Selvin, and which I think, part of the program is directed to, is can this be more data-driven? That is, it sounds to me, as I hear you, that you're making, or the lawyers that work for you are making, a series of judgments about individual case versus a group of case, judgments about particular cases in particular jurisdictions and judges and so on. But when you're doing that, are you relying on the judgment of the people making those decisions, or do you in fact have a secret sauce at the Hartford that you can't talk about, that you put this data in and it comes back with some information for you?
Of course we have a secret sauce. No, look, I would say most, I won't talk about the Hartford, but I'll talk about most companies of which I'm aware. Insurance companies have lots and lots and lots of data on liability type issues, right? The data hasn't been collected. It's been collected over a long period of time through lots of different mechanisms and for lots of different purposes. And there are very substantial costs to cleaning up the data, if you will, to putting it into a form that's usable. It's a cost worth bearing, probably, at least in portions of the data, but it may not be a cost worth bearing now. In other words, there may be better uses places where the company can put that money and make a higher return, or has at least established that fixing that data piece. So I would say most insurance companies are aware of the data that they have and have either begun or thinking about how to take the data that they have and use it in ways with respect to litigation valuation that are going to bear fruits.
Let me shift gears and let me get Liz involved here. So Liz is currently a partner at Paul Weiss. I may have mentioned that. Prior to that, you were head of litigation at Citigroup, and then prior to that, had Jim's job here in Hartford. So from your perspective, you see a variety of clients, primarily in the financial services industry, and you're counseling them from the outside. Presumably, Paul Weiss, given its stature and its success in litigation, probably has some of its own internal secret sauces. So from that perspective, if you can comment either on Selden or on Jim's comments, that would be helpful.
So, people don't come to Paul Weiss for their portfolio litigation as a general rule. So they're coming with the what I call the oh shit matters.
We're streaming this, right?
So they're coming with the things that are big, potentially existential threats to the enterprise, that are different from what they've seen before, and they are scared and they don't really know what to do with them. So from the client's perspective, these are, relatively speaking, sui generis risks. They're not sort of putting it into an experiential bucket of things they've seen before. So notwithstanding the fact that these are all either public companies or in some cases companies with a lot of outside money, even if they haven't gone public yet, so they are all having to accrue or provision on a quarterly basis this liability. So they're taking an immediate loss at such point as they've reached a point under the relevant accounting standard that they have to take a charge. Notwithstanding that, which you would think would lead to a very sort of, hard-nosed financial data-driven valuation of the liability along the lines that Selvin was describing for the other side of the V. What they really care about in those situations are the soft variables that are very hard to express in financial terms. And to perhaps a surprising extent, those soft variables end up being what actually drives a lot of decision making. So what do I mean by that? Well, I'd say first and foremost, reputational risk. So let's say you're a company and there's been a more or less credible accusation against your CEO of sexual harassment. 3 years ago, maybe you would have, handled that as a litigation risk. Today, what you care about first is that your company not be put in the Roger Ailes, Harvey Weinstein, pick your favorite miscreant bucket. So you are going to manage that first and foremost from the standpoint of protecting your reputation. And if that means you have to, overpay to shut something down quickly and quietly, you're happy to do that because your reputation is much more valuable to you than having to write a check for a piece of litigation. That can be equally true in what you might think of as a more purely commercial context. So let's say, for example, your Volkswagen. You got your little diesel situation there. You're going to, pay money in litigation and pay money in regulatory fines, and the recall, usually it's expensive, I've got to think. But what's really going to reap the greatest long-term detriment to a company in that kind of situation? It's that your brand is now associated with cheating and not delivering the product that was promised. And that, has a very long half-life. So I'll give an example there. We all read in torts about the Ford Pinto and how it didn't work out so well for Ford that they, saved a little money by putting the gas tank right where it would explode if the car was rear-ended. So I was a teenager when that was all going on, and to this day, if we were playing a word association game and you said Ford, I would immediately say Pinto. And the image that would be in my brain would be a car exploding. So that's what you don't want if you're a company dealing with something that imposes reputational risk. And that was felt very powerfully in the financial services industry through the financial crisis.
To that point, though, as you talk about some of these other risks, it strikes me that how you prioritize risk or how you prioritize the elements that cause you to approach a piece of litigation in a certain way, once again, is a heavily experiential judgment. I feel like as the four lawyers up here are saying, we can figure this out, we don't want to turn this over to a piece of equipment. I'm trying to play devil's advocate here and try to understand whether that is necessarily true or whether you think there are places for data. Are there things that you're, and I'm going to get to you in a moment. You can respond.
Can't be too quick.
I mean, where do you see the possibility for more data-driven, analytical, artificial intelligence type decision-making, if there is one?
So I think the first step is to persuade the decision makers that data can help them, and I don't think we've gotten there yet. The people who make decisions about litigation risk are largely lawyers, CFOs, sometimes in financial services, certainly risk management teams, and business people. And very few of those constituencies have any background or training in any kind of statistics. So you're asking them to trust a thing that they don't understand, that they don't really, know the power of. And you also are dealing with a culture within the bar, I think, to believe that our experiential judgment is really our key differentiator. That's what makes Bill better than, guy down the street. So I think that the question kind of still needs to be posed and answered in a way that will persuade people that human experience plus data analytics is better than human experience alone.
You had a point, so go ahead. Go ahead.
Yeah, this is an important point. I agree with Liz that data is important and getting the importance across to clients is important. But she gives the greatest analysis of what I think of as an investor of what we work on, reputational risk. You don't think that we take that into account very, very carefully before investing in something? Reputational risk is known, it's been around for a long time. Clients understand it. If you can talk to them about it, forget about the data. Forget about the human judgment. Just talk to them about it. Now, how do you get to talk about it? Well, you need new tools. This whole industry needs more reliance on neurology, brain theory, psychology. This is what is missing from every field. And if you sit down with a psychologist and he tells you, look, this CEO is scared to death of darkness, well, that's a big factor in your risk analysis. Or he says to you, your claimant will fold at the very first whisper of risk. Well, that's important as well. So I think that the big analysis here that's missing is one that we will see in the next 10 years, and it's going to be one that's used both in finance and in litigation risk. Litigation finance risk and litigation risk.
Right, but you have to persuade the decision makers that what you have on offer is better than what they already have. So let me give an example. And I have to tell you who the client is for this anecdote to make any sense. So one of my clients is the Bank of New York Mellon. So I was, talking with the head of a litigation at the bank one day, and we were talking about trying to resolve something, and jury testing came up, and she told me a story about a matter they had in Louisiana, and she had asked her nice Louisiana counsel in the matter if he'd thought about doing some jury testing because they were heading for trial, and he says, "Ma'am, here's what I need to know about the jury. Your first name is Bank. Your second name is New York."
But Bill, on reputation, that's good. And that's, having had some cases down in that neck of the woods, I understand how it works. But on reputational risk, for example, again, I agree with everything that Liz said in terms of the buy-in that needs to be achieved. But there actually are some pretty interesting work that's being done with data out there right now, taking different types of reputational hit, different categories of reputational hits, and then either trying to tie it to reductions in sales or stock price drops. And I don't know how good the data is right now, but but it's interesting to see that certain types of hiccups, if you will, seem to tend to cause greater ultimate financial harm to the company than others. And that could be informative in deciding how much weight you want to put on reputational risk versus the cost of resolving litigation.
So let me do this. Alexander's starting to look at me, which tells me we're running out of time. But I want to finish with this thought, because we have two other panels who are actually going to, I think, talk a little bit more about some of the work that's being done in some of these fields. So, wish list. Let me start with you, Jim, and then come this direction. What kinds of tools would you like? What do you think would be out there that would help you, and what kinds of problems might those solve and not solve for you?
Yeah,
so
I'll be
throw it to the other panels and make them do the work.
Right, I'll be very quick. No, for me, the primary thing is better data. It's more about
what kind of data?
Outcome data is important to me. I think more complete data on outcome data that goes beyond my experience, in other words. I think partly it's so difficult for me to answer the question because in order to maximize the use of the data, I think I need to identify certain attributes of a case that I want data about, and we may not yet be at the point in which I can tell you the 10 things that I want to know about a certain type of case. But I think more conversation around that and then more data to follow up on it would be my answer.
So one thing we haven't talked about is litigation cost, which is part of the litigation risk from, certainly from the defense standpoint and from your standpoint as well, Bill, if you're deciding to put your assets into pursuing a recovery. So for me, the sort of low-hanging fruit that I'm surprised we don't have better tools for would be to be able to analyze the data that we all have in our own law firms. We measure our lives in 6-minute increments. We know what everybody is doing all the time. Well, yeah, you did, Bill. And we don't use that nearly as much as we could to figure out how we can deliver the same product more cheaply to the mutual benefit of the law firm and the client. So that's sort of the low-hanging fruit for me. And then I think, consistent with what Jim is saying, having tools that can not only give you data about outcomes, but put them in a context. So if you could, for example, say, if I lose on this issue, what will the impact be for my portfolio? How much is that really worth to me in the aggregate? I think that would be a hugely useful tool. And then I'm very curious about some of the sort of psychological, neurological, behavioral analysis that Sullivan referred to. It would be interesting to know more about that.
George Washington, any last comment?
Yes, of course. There's more than one thing I think our industry needs. Our industry needs more information. It's a secret society, and I think that its secrets are, one to the next. So we need more information, and part of it will come from experience because it's a young industry. But it's also very confidential. The other thing I think we need to do is the selective data analysis. I think we need more technological skills like artificial intelligence, like data analytics. But the most important thing I still think is having a neurologist at your side to go into the brain and look at how it's hardwired and come to some conclusions about your client, about the other side, about the lawyers. So that's going to come, but not too soon.
Well, I want to thank Jim, Liz, Selvin. We're only 4 minutes over. So I want to thank the panel for setting the table for the rest of the presentations. Thank you.
Thank you, Bill.
We have a short break until the next panel is seated, and you're welcome to have a cup of coffee until we regroup.
You never go into breaks. Breaks and lunch you don't do.
What happened to Liz?
But it's good. It's good. It's absolutely.
You're the first panel and you're behind.
Oh, yeah.
No, I mean, we had 2 hours of material to put in 40 minutes of time. Oh, I meant to tell people about your article. I meant to tell people to make sure they get your. I'm going to have, when she comes back and introduces the next panel, I'm going to make sure people know that you got some piece out there. Yeah.
It really takes.
Right. Yeah. So we're still small enough, even with 100-plus lawyers, that there's a small group of us that if the litigation is essentially an extension of existing litigation, so if we're doing a mass tort and we've got 500 people with bad hips, taking 501, no big deal. If we're getting into something like opioids, which we are now in, then there's a committee that sits down and does an analysis, but nothing nearly as sophisticated. I mean, I think
From the moderator.
the problem with lawyers is we tend to believe in our own infallibility, and we tend to believe we understand this stuff. And the real issue, I think, is for plaintiffs' lawyers is there's a certain case bias. If you develop a case, you become invested in it, you love it, and you love it, you fall in love with it, and you don't see it. Right, and I tell our lawyers, they'll come to me and they'll go, oh, this is really great, so-and-so did this, and they did this, and they're really bad people. And I say, okay, let's take a step back. Let's kind of look, where is this going to be? There's an arbitration clause in that. And we go through all the step by step, and then they're like, gee, that sounds like a hard case. How are you going to prove causation? How are you going to prove this? So it's a pretty rigorous process, but I will say, we could be a lot better at it. There's no question.
What you're doing, I think, is 10 times better. You realize the problem.
Well, your issue on psychology, neurology. I don't see anything. Poor cats get too long. Lily.
Hi, is anybody here a tech person? Or just somebody, I have I'm a panelist, and I
Okay.
do a presentation.
Okay, I'll go grab someone.
I think it's Colin Faulkner.
Oh, are these all matched?
Yeah, these are all set. This is the order she wants them in this order. The rest want more water? We need one. We're good actually on water. We're fine.
Okay.
Wait, hold on.
Is that what she's trying to do now? Yeah, so the PowerPoint, is it on a USB or is it on email? Okay. You might want to get some. There should. think it might be, that's why I'm asking to email, because sometimes it's easier to email because the USB is not as easy to access, because you might have to email.
Well, I also emailed it.
Yeah, if you emailed it to yourself, it's
I
probably
did.
easier to open up on the email.
Hi.
We're putting yours up right now.
Where do I control it from? I didn't know. So the picture's right there. Do you want it at the beginning of the panel or only when he's speaking? Or do you want that title?
At the beginning of the panel.
Okay.
You can put it up at- That's fine. Is that okay with you?
Yeah, I don't care.
I'm just gonna pop out.
Yeah. It's a good thing I'm staying. I got to hear what you're doing.
I don't know. I'm writing it out right now. It's never too late.
Make us look bad. You have a presentation?
What's that?
Does somebody have a PowerPoint?
I didn't know we were doing PowerPoints,
Well,
but I have
I'm concerned that I'm going to be.
I have nothing short of.
You don't have any slides, do you?
I don't have slides, but I do have slides, as you know. I've only got about. I think I did a count on it. I think I personally generated, somewhere in the range of, about 7,000 slides across all my classes and everything. Yeah.
Mark's got the slides, yes. Mark's going to make us all look bad.
Okay. Wow.
Well, he's the elder statesman.
He's been doing this
Right. You're sitting that first seat. It should be fine.
Hi, I'm Dan. Nice to meet you.
Walking under the flag. Okay, so it's hidden, but
Are you pressing the right? Okay.
yeah.
I'm gonna do this for you. Try it again. Point it up a little. Can you punch this one?
I'll stand up. Try it again from where you are, just to make sure that. Try it.
Erica had me up to the wee hours of the night.
I
there.
had no idea how late it was.
I know. I got
I walked in, it was like midnight. I was like,
Oh, you're just having a nice time.
yeah, I like that restaurant.
Yeah, it's
I'm
nice.
gonna go back.
The one in the hotel,
one in the
it's
hotel.
brand new, but they let us in. It was a friends and family, so it looked like a nice place.
Yeah. Yeah, it's cool. They were nice people. Yeah.
No, that doesn't.
Why don't I just do this and press the right arrow and see if that works for you? Yeah, let's do that. That'll work better than this.
Yes.
Can you test it? Just go right in this one. All right, perfect. That works. And I'll be watching, so if it stops working, I'll come up. Can I get one of your students to write my code for my final project?
I don't know if I believe I shouldn't be an accomplice to that particular exercise.
I woke up this. I don't know if this ever happened to you when you started, coding, but I'm starting to dream about coding.
Oh, yeah,
and it is
absolutely.
so annoying. Like it's the worst.
It is.
Oh,
It is.
It's like you think about the puzzle.
You're really having
You
the
know?
mind meld. No, it's a great puzzle, though. I mean, it's fun to do. I mean, when you think about it, you know, the notion that puzzle oriented. It's like, well, why does it work? Why is it working? Like interrogating that. I don't know. It's great.
No, I don't mind that.
Yeah. The dreaming part. Well, that's like where you really cross the Rubicon now. There's no going back.
I'm dreaming another language.
Yeah, pretty
I
much.
thought the last panel had 5 more minutes.
I also
This
did.
is to 10:35.
Yeah, I also thought they did, but you know what?
I woke up in the middle of the
The
night
thing is,
and it was like I figured out somehow I like saw it and I
I'd
had
like
to
to hear
almost
more
like
about
race
the different types of risks that Liz was talking about.
because it's like you know I'm gonna forget this much.
But
And
what's
it
good
did
is
it
I
actually
got the
solve the
intel
problem.
from her, so.
That's nice. That was a good moment.
I think
Spinning my wheels for a really long time.
Yeah, no,
Something in hindsight which really wasn't that hard. Yeah.
it's amazing when you're unhappy with what you're doing, what's happening on because, like, I had all of those moments when I hated being but they weren't epiphanies. They were, oh my God, I forgot this. Oh my God, you know, so you only think about the negatives.
Right.
It's so refreshing after 20 years to actually wake up and go,
yeah, let's see if we can do
like, oh, you know, it's like, for me, it's the whole
Yeah, I guess that's right. I mean, our the lawyer mindset is more of a reactive, protective, not like forward, sort of like we can solve this problem.
Yeah,
And
it's so much.
right. You're always reactive.
that's exactly right.
Yeah. No, this is the.
Well, it's the time consumption on the core work.
Yeah, like when you're an engineer, you know,
Things that come to your
on that problem solving, all
Yeah,
that
yeah,
stuff.
there was
Specifically what you has to say. We probably have
Supposed to
questions
be our
for each other, but I think it's in the audience.
the way we're gonna do it is, it's gonna be.
This is why I think media market a lot of these proclamation of a lot of these people. Like products and service graphics around it because you know people out there just want a solution, so they're kind of agnostic as to how that's and so that's really I don't know where that's what we see a lot of
They
people
don't even
say.
want to know what happened.
Certainly the above even your second house counsel above that is the chain. It's like I don't know, just like through what it was. I'm very agnostic. We don't have a problem or whatever. Right. Yeah. Or like even on the transaction side, I was like, let's say it's deals that's like it. But like how you go about making that happen is really on you to sort that out. Oh. Okay. Mark's doing some slides. Okay. Okay. Yes. I'm sure I do. I think I know what he'll say in the slides. Hopefully. Oh well. Yes. I'll take you. I'll react. I'll react.
So we're not going to give it the presentation then? Well, you said 5 to 7 minutes. I talk about Mark in presentation, don't worry.
Yep. Okay.
Yeah, not really. 10:45.
It is, okay.
Seems like it's on.
Yeah. All right, we're ready to start. If everyone could be seated. So for our second panel, we have four really amazing panelists, I'll just introduce them very quickly. Their bios are in the materials that you got. We're going to start with Mark Victor, who's been a real pioneer in the development of decision tree analysis for evaluating litigation risk. After Mark, Daniel Katz, who's a professor at Chicago Kent and also an entrepreneur and a real leader in the fintech space, will talk about some of the work that he's been doing in thinking about what more we can do with data analytics in this area. And then Andrew Cohen, who's a vice president at Burford from the litigation finance area. We'll talk about some of the tools that they use. And finally, Eric Falkenberry, who's a partner at DLA Piper and has been doing some very exciting pioneering work, also trying to use some data analytics to get some purchase on the issues that were raised in the first panel. So we'll start with Mark, and then after the presentations, we'll open it up to your questions. What I ask is, if you have a question, raise your hand so a student can come with a microphone so that everybody in the room and also out in the internets can hear your question. And we'll start with Mark Victor.
Thank you. Can you all hear me? Is that okay? Okay. There's really only two things you have to worry about in evaluating litigation risk. And this won't come as a surprise, but it's garbage in and garbage out. Now, interestingly, when I first started teaching lawyers decision tree analysis, a criticism, which I still don't understand to this day, is, oh, well, you know, garbage in, garbage out. And I would say to the lawyer who said that to me, but aren't you hired because the client thinks that you're not going to give garbage opinions, that you actually have good judgment? So to me, one of the big problems is the garbage out. And I don't think that's well understood by most clients, most attorneys. And garbage out is the failure to take your very good thinking about what's going to be important to the judge and jury in your case, given your facts, and you've thought about all of that, but are you then putting all of those judgments together, your judgments about what's important, what's likely to play well or not, and are you putting that together well and reaching a value that's consistent with the view you held on all the pieces? To me, that's the garbage out. And the only way to have you appreciate it is to have an example. So I'm going to want everybody to think about this case. Your client was sued by a long-time smoker who has stomach cancer. He claims it was caused by neighborhood exposure. So he's not a worker, but lives in the neighborhood of your plant, so exposure to a chemical used in your operations for decades. Most scientific literature finds no association between this chemical and stomach cancer. Plaintiff, though, is only 46 years old, a few years left to live, is going to leave behind a wife and two teenage children. So that's just background. Okay. Here are the issues you've identified and your assessment of the strengths and weaknesses, and these are the only issues you think matter. The first is you think you have a 20% chance of winning a motion, an 80% chance that the trial judge is going to deny your motion to dismiss on the issue of medical causation. No link between the chemical and stomach cancer. 80% chance that's going to be denied. If it goes to the jury, though, you actually are concerned that 10% of the time, jurors are going to hear about operations at your plant and just it was kind of a messy set of operations for decades. And they're just going to check the box liable and jump right to damages, not even consider your defenses. But 90% of the time, they will consider your defenses, and if they do, you have two defenses. One is no real exposure to your chemical. They lived in the neighborhood, but no real exposure. You think you have a 1 in 3 chance of convincing the jury that the plaintiff did not have exposure, which would lead to a defense verdict. Even if they think the plaintiff did have exposure, you think they'll buy the lack of medical causation 1 time out of 4. If they find you liable, even though they've thought about your defenses, they heard your witnesses, they still think there was exposure and it caused the cancer, your damage range is 8 million, you can see, down to 2 million. 1 in 4 chance around 8 million, 50-50 chance around 4 million, and at the low end, maybe a 1 in 4 chance around 2 million. Now, remember that second bullet point. If they were really mad and just kind of jumped to damages because it was a messy operation, you think those numbers are all like 25% higher, so maybe 10 million, 5 million, 2.5 million. So, no matter what your age, you're a student here, write down on a piece of paper what you think is the value of the case. So in particular here, if you were defendant, you would you'd pay up to X dollars to settle. Don't worry about reputational risk. I'll have comments about that later. Not that it isn't important, but I always say let's have a starting point for understanding this case on its merits. And factored in here is the venue. I mean, that's in your odds. How good is the opposing counsel? What's the judge like in this case? That's all built into your odds. These are the only issues that matter. You think you ought to pay up to X. Oh, and don't worry about legal fees. You ought to pay up to X to settle. Otherwise, you should go to trial. If the plaintiff wants more than X, you go, that's too much, that's too rich, I'll go to trial. We don't have a lot of time, so I need you to quickly write down a number. The highest damage amount on here is 10 million. The lowest would be 0. What strikes you as, these were your opinions, what's the most you ought to pay to settle? No, I'm not asking for answers yet. I need everybody to write something down, because otherwise we run into all this psychological and neurological stuff. You throw out a number, that's going to anchor everybody else in the room to go, oh, really? Huh. So y'all have something down. I know this is quick. So, and this, I mean, this is a pretty clear description, yes? Of a problem? I mean, we have to do this quickly, but raise your hands if you said, yeah, we ought to be willing to pay, even if the plaintiff wanted $4 million, that we should do that rather than go to trial. Anybody in the 4 million or higher range? Raise your hands. Okay, look around the room. We got a half a dozen. We got a half a dozen or more. Okay. How many of you are in the 3 to 4 million? Up to 4, but 3 million up. Okay, 1, 2, 3. 2 to 3 million. Raise your hands. 1, 2, 3, 4, 5. 1 to 2 million. Raise your hands. Okay, 8 or 10 people. Less than $1 million is all you should pay. Otherwise, given your defenses and so on. Okay. Now, I've got about the same number of people. I'm being generous there, but about the same number of people in every category from above 4 million to below 1 million. Can you all be right? This is what I call garbage out. So you can share the same opinions about what are the important issues, the same judgment calls, and I think you have good judgment. Now, the panel is going to talk about how can we improve the judgment, the avoiding the garbage in part, having better information, having probability assessments that are more realistic. But if you've already got something, and these are your opinions, the fact that you're all over the map, to me, that's what I call the garbage out. And of course, old style evaluation, just this is always fun. By the way, if I said to you there's a good chance of something happening, immediate reaction, good chance, how many of you think, oh, that's like 60 or 70%? Raise your hands. Okay, I got 4, 5, 6, 7 people. How many of you think good chance is 30 or 40%? Raise your hands. Okay. So this is the way lawsuits still, there's a lot of discussion. It's very likely our motion will be denied. There's a distinct possibility the jury's going to do this. We got a good shot on our exposure motion or argument to the jury. We got a fighting chance on the causation. They certainly could hit us for $8 million, but more likely around $4 million. And it's not outside the realm of possibility they'd award only $2 million. What's this case worth? So decision tree analysis, if you're not really familiar with it, says let's see the issues graphically. Motion denied or not. Jury's so mad they just jump to damages, or do they go through our defenses? If they go through our defenses, what do they think about exposure? What do they think about causation? And if we've lost the top one, they're awarding 25% more than the range of the $8 million to $2 million that I mentioned. That's a graphic of the paragraphs. We put in probabilities. And then there's a process that's been around for centuries that says you can combine probabilities in dollars to come up with, first of all, what's the probability of following any path out. So imagine you tried this 100 times to 100 mock juries and judges. You had mock judges and, I always like that term, mock judges. How many out of 100 would end up on each path? Given the dollars involved, the calculation can be done. You can all get a copy of this, and there's lots of papers that are free downloads at my website if you want to understand more. I obviously don't have time to talk about the math, but I do want you to realize that if you've done a good job identifying the issues and your judgment comes into play on all these probabilities, they're subjective, you can avoid the garbage out problem. And that average value is called an expected value. It's really powerful for 3 reasons, 2 of which I have on the slide. One is it's the best way to combine your best guesses. If you can settle at or below that, you minimize your exposure across your portfolio. It is the same concept used by insurance companies to set premiums. If it's good enough to set premiums, anticipating that some people are going to have claims, you know what? When they have claims, you ought to use the same process to value the claim. And it's good enough that it's taught in medical schools for doctors to make life and death decisions. Now, I've only got a few seconds left. There is more than the expected value in large cases. So instead of this range of 0 to 10 million, imagine it was 0 to 100 million. Risk aversion comes into play on both the plaintiff side and the defense side. So mediators can make effective use of this in trying to get parties to resolve disputes. Avoidable legal fees, Liz is talking about, precedential concerns, impact of publicity. There's all kinds of things that you have to layer onto this, but I think you ought to not start with a bad conclusion from all your judgments. You ought to start with a good conclusion and say, now I need to take other factors into account. Garbage in also has to be avoided. What issues go in the decision tree? How does the tree get built? What goes first? What goes later? There's some work that goes into learning that. And then how do you come up with good probabilities and verdict ranges? That's the garbage in side. Thank you.
Yes, hi. So I'm Dan Katz. I'm a law professor at Chicago Kent College of Law, which is the law school of Illinois Institute of Technology. I'm also run a company called Lex Predict. We do artificial intelligence, predictive analytics across the legal industry, work with a number of Fortune 100 companies and a number of law firms. And I just would pick up with Mark and just say the big question when it comes to something like what he just presented is where do you get the P's from? Where do you get the probabilities from? Historically, even if you're going to do that analysis, you would take a subject matter expert in there, generally single subject matter expert, and in the cult of their own decision making, establish a P. And the plausibility of that P is a very open question, and I think that's the entry point for machine learning data analytics is to test the plausibility of those Ps over time. And I just would say, the case for models is that a subject matter expert can probably, at least in our experience, can generally define the parameters of the problem, but can't put the weights, the feature weights on those different parameters. And so the case for models is that you can do a better job, at least at the portfolio level, of assigning those probabilities. So I'd just say that kind of at the outset. Real quickly, I'm just going to kind of, I've been accused of engaging in nonlinear conversations, so this will certainly be reflected in my comments here today. So I teach at Illinois Tech, Chicago Kent College of Law. I run a thing called the Law Lab there, and basically we sort of stylize that, because we're at a technology school, as sort of an applied technology center with sort of law as the domain of application. Examples of work we've done. We built, teach the students to build models. I teach a machine learning class to lawyers. I think it's maybe the only one in the country. We teach a blockchain class, crypto class. We teach process improvement, which I think is really needed in a lot of areas of law. I mean, law's got a lot of waste and can be made better. And then, some of these basic risk management tools that you see, on display, both in or discussed in the prior panel, and you'll probably see across the course of today. So that's a little bit about what we do at the school. The company, we've built models both that have been used by funders, but also, and any organization who has something on their balance sheet isn't a litigation funder, essentially, right? They're running their own self-insurance fund. So the question is whether they bring the sort of quality, of actuarial science or data science to bear on their own risk management as an outside party would if they had to bet their own money. And the answer generally is no, but a lot of organizations are trying to become that. So that's kind of like where we would come in. One of the things we would bring to a problem is when you go to most of these organizations, whether it's a law firm or corporate legal department, they're basically data superfund sites. I got to put a hazmat suit on to clean up, right? So in theory, they have all this information. They have lots of information, but it's deeply unstructured. And so, it's in a PDF that has to be OCR'd and extracted. This is whether it's their contracts or whether they're documents in their document management system or just on their email somewhere. So, I mean, if this rings a bit true, this has been our experience. And so even to do these problems, you need to actually go through the organization and extract and pre-process and extract the relevant information so that you might be able to build a model. So again, theoretically available but practically unavailable is basically the state of play. So they're not in a position often to even leverage the stuff they actually is right underneath their noses. So that I just would say that's kind of the state of affairs as we've experienced it when it comes to the desire to build models. Prediction is a core task for lawyers all over the place. People call upon a subject matter expert to make a prediction. They do it in transactions. Oh, I want this little deal term versus that deal term. They're doing risk transfer tennis. They trade this. I'll trade you this for this. Back and forth it goes with no model. No explicit model that sits around any of it. It's just a person's typically a cult of a single expert's view about the subjective value or risk of a particular, whether it's a term in a deal or what's going to happen in a case. And I think what we've seen, one of the great exercises we do, we built a little, it's not that fancy of a thing, but it's basically a tool that we would call to do legal underwriting. But basically, it's walk people through these scenarios and show them in their own organization how much variation there is, very much like Mark's exercise. Just among the people that are supposed to be subject matter experts, there's so much variation on what would purport to be relatively straightforward things that, again, I think the question is, can everybody be right? Probably not. What you'd hope is, same rough facts, I get roughly the same answer with some variation. But no, we see in a lot of problems, there's massive variation in terms of like how people would characterize these matters. So I think in that respect, we're not really a very disciplined field, and we can do better. And I think this is the way in which sort of fintech and legal tech is growing very rapidly. Those are on a collision course with one another, especially around use cases like this, like managing legal risk. That's basically fintech by other means. So my theory is try to borrow the principles that you're seeing in fintech, where fintech's kind of two things: managing increasingly exotic forms of risk, and basically streamlining previously kind of hard to rationalize financial processes. That's kind of that's the whole field. So that sounds a lot like law to me, both those things. And so the question is, can we do better? And then when it comes to predicting things, and this was discussed on the first panel, what our goal should be is to try to combine experts, crowds, and algorithms in a plausible sort of way. And again, if you're running money professionally, this is what you do. If you're running a trading desk, unless you're doing like algorithmic trading, you're going to build a strategy. You're going to use your subject matter experts. You're going to blend that with some sort of model. And the question is, the very difficult question is, how do I optimally blend those streams of intelligence to make decisions? So it's not all experts and it's not all algorithm, although, there might be places where we go to our version of high frequency trading, but I think a lot of most of the problems, especially the higher end problems, are going to involve some mixture of the two. The other thing I would say is mixing experts. So getting multiple experts, but segment them so that they don't, bias each other by their representation of the problem space. So again, those are kind of just some thoughts on all of this. Last thing I'll just say, my own academic work, I've done work on predicting in this Supreme Court decisions using machine learning. But the other thing we've done is been using crowds to predict those things. And then the next thing you would do is roll those up together. So that's stuff we've done. The other thing we've done is trend spotting. So an example would be mine all the 8Ks and 10Ks and try to surface emerging legal trends. An organization, this is what I did that academically, but after doing that, an organization came and said, we're trying to figure out these emerging risks, legal risks, and we think it's all in there because people are there, but we can only see like these little slivers. Well, we want ways to surface that at scale and try to understand, well, basically, we want to push that risk on somebody else, but we just we don't even have complete visibility into it. And so I think these problems are largely underneath our noses, but they're hard to surface, and we need better tools and techniques. And I think that's true for litigation risk, and that's true for kind of a range of risks that lawyers are called upon to help manage. So those are my comments.
Andrew?
Hi. So first I have to confess, I have a great self-interest here because if the world that Dan is trying to bring about were to occur, I would be out of a job. And so I bring to the table a bit of skepticism.
You got to disagree with me then.
I mean,
we're hiring too, so.
All right. Either way. So in part, so what I'm going to do is I'm going to distinguish between the types of modeling that we do use and the types of modeling that we remain highly skeptical of. And so what we use at Burford is, to some extent, the big data analytics in specific areas. For example, in the patent space, there are a lot of products out there that are good at, trolling through all patent litigation, patent databases, and, doing some of that first level analysis. And I think one of the reasons, there are several reasons why that's true. And one of the reasons is, you've got a limited court space that you're working with. You're in the federal courts. You have some correlation maybe between individual courts and their practices or individual circuits and their practices. So there may be some more predictability there. And you have specific litigation decision points. What Markman hearing, or if there's going to be IPR, you can sort of take those out and look at those individually. And then you can also do a decent analysis of prior patent prosecution or prior litigation. You can get a lot of information out of that through machine analytical ways. But when we do that, we're not looking at necessarily the conclusions that are being drawn by the big data. These products, they will say, oh, you got a 20% chance of winning on this patent, or 80%. We're not relying on those. We'll take what they've given us as a digest of the record and as a starting point for our own analysis of the picture. And that's one of the places where we use this sort of approach. The other place where we'll use the approach is in our own valuation process. We have to, we're a public company, we have to have a valuation for our assets, and we have a valuation process that involves modeling the value of each litigation. We're lucky because as financiers, we're starting with a data point, which is what did we pay for this litigation? But that quickly becomes outdated because litigation moves along, and what we paid for the litigation in the first place was really just the agreed upon price between us and the seller. So that's not, that may not be an objective valuation. So what we have to do is we have to look at the future value as the litigation moves along, and we have to forecast the cash flow. So we use modeling for that. What we don't do necessarily is use the predictive models, third-party models to say, if you bring an antitrust litigation in the Third Circuit, you've got X percent chance if you're in front of this judge. That is just, we look at that, and right now we don't believe in that. We don't really factor into our evaluation models, some of the other risk factors we've talked about, reputational risk, precedential risk. We have, in litigation finance, we have regulatory risk as well, because we are a new industry, and there are potentials for being involved in the wrong way, in the wrong cases, to bring down a regulatory hammer that would be harmful to, existentially to us. So we have to look at those, but we sort of look at those as outside of the valuation of any individual litigation. So when we're looking at valuation models, what do? We actually, we use some of Mark's techniques, and we use them in a way to be more rigorous about our decision making for many of the reasons that Mark has discussed. Because you start with when you start at the valuation of litigation, you start with okay, well, we're going to do a gut value. We know what it was worth when we bought it. We think it's gotten better, so now it's worth X plus, or maybe it's gotten worse, and it's worth X minus. But that sort of gets less useful as your portfolio gets more complex, and so we've really gone much more rigorous in looking at the individualized, decision points, getting external indicators of value, and then using some sort of analysis like this to document what we're doing, so that we can look back in 6, 12, whatever months, and say, okay, well, that's what we thought then. What's changed, and how are we going to tweak that based on the development of the cases? And Burford's portfolio is composed of large litigations generally, and so those tend to be bespoke, all of them. No two litigations are the same. They're unhappy families. And so when we're doing these models, we are developing them individually for each case. So there's actually a lot of complexity to putting together. We don't have a standard model that we say, okay, well, this is our litigation, and we tweak the same factors in each case. We really do have to look at what are the decision points for each litigation that we've invested in. What are the percentages? What are the damages? And sort of do that for each one, and acknowledging that all of those decisions, how to structure it and what goes into it, all of that is subjective, and we acknowledge that. In more complex cases, MDLs or other sort of multi-stage litigation campaigns, you get even more complicated because decisions you make early on can have effects later on, or it'll actually even affect how the litigation progresses, and how to model those in a way that makes sense and is predictive in some way is the real challenge, I think. And then, we plug a bunch of numbers in, and then we also still have our intuition. So we'll reach sometimes we'll do a model, we'll put in all the numbers that we think make sense to us, and we get an unintuitive result. And that cuts to the back and forth to either, tweak the likelihood of outcomes based on, further discussion internally, look at damages ranges, all those things to sort of understand how did we get to that unintuitive result based on all the things that we thought were the case. And sometimes that leads to an insight that we didn't see before. And maybe that changes how we feel about the case, or maybe it changes how we value the case. When this individual case modeling was sort of what I've been talking about, that all gets an added extra layer of complexity when you are investing in a portfolio of litigation, because now our return is based on the performance of a number of cases within a portfolio. And then the question is, do you model each case individually? Do you sort of make some simplifying assumptions? And so those are challenges we get when we're valuing in a portfolio that we don't see in individual cases by themselves usually. So that's valuation. That's something we do. Why don't we like predictive modeling? And now I'll just pretty much yell it down. So the data sources, as Dan has said, we have real problems with the data sources available. You go to courts and you've got some information available to you, but not all. We have no information about size of settlements, and I welcome anybody in the audience who wants to tell me all about their proprietary settlement data. Give it to me, I'll be happy to take it. There's no state court data really that you can get for broad across the country. You don't have a situation like in actuarial science where you have standard metrics that you can just measure against. What would that even look like for complex litigation? What does winning on a motion to dismiss mean across litigation? You have to find a meaningful question to ask in order to find the data to answer it, and that is a real challenge for us. Natural language processing of opinions, it's getting there, but in our opinion, is not really there. And whenever there's a human intervention to sort of tag things, there's problems with that. We are able to look at the underlying court decisions, but then there's an appeal that has to be taken, and sometimes those later developments are not taken into account. Then there's a suspicion that courts sometimes act also intuitively on their guts, and so that you look at all the input data and you may get to the wrong result based on a model because there's extrinsic factors. Then, just quickly, the other issues that we have with predictive modeling, generalizing complex cases feels wrong to lawyers, and we are a very lawyerly business, and so there's sort of a instinctual, this can't be a thing that works, because if it does, then we're all doing something wrong, practicing law.
No, that's hard to stomach, but it could be true.
Well, yes, absolutely, and that is why,
I think you're sort of like, this is like a therapy, so you're sort of walking yourself right into all the way around.
It may be. Because when you look at, can you abstract by, the area, nature of case, venue, judge, if you can abstract those things away, then the practice of law means something else, I think. And that may be true, but it's troubling. And there are additional issues where, since we're in litigation funding, the application of litigation funding may actually affect the outcome, and sometimes we hope it does. And so the question is, would an extrinsic model based on sort of the data that exists out there where most cases weren't funded still hold for cases where we're now applying funding? That's an open question.
Andrew, I'm going to interrupt
Yep.
you because
I'm out of
my
time.
prerogative as
go for it.
moderator.
That was
But
it.
we'll get back because we'll have an opportunity to ask questions. So those of you that have questions about whether you should keep being a lawyer after you heard what he had to say, we can
Or
ask
drop
him
out of
that.
law school for
Yeah, you still have a chance. So Eric, if you could share with us your remarks.
Mark, would you mind putting up your slide number 5?
Is this still?
Yep.
Yeah, but
Help us out.
I don't
We have
have
a
a-
tech
I don't
guy's
have a
about to
mouse.
do it. If you could start
Okay, I
talking,
can start, no problem.
we're going to
So,
get it on.
I wasn't going to
Five.
tell this.
or just get back to it.
I wasn't going to tell this story, but the slide reminded me of this story, and I think it's appropriate for our topic here today.
Which one is 5?
Is it the tree?
It's the one where you got all the lawyerly answers about.
It's the one before that.
Previous
That
one.
one.
There you go.
Okay.
Up right before. I'm sorry, I didn't mean to screw you up. So anyway, about 5 years ago, I was asked by one of my transactional colleagues to come into an M&A situation and assess some rather significant litigation risk of the target. And typically what we would do is during the day, we would review documents, conduct interviews, so on and so forth. And at night, we would huddle with the client and discuss our findings. And the sessions would always, start with the same question. What is the risk? And what this slide reminded me of is the answers that I gave him the first few nights, which were, basically, well, the risk is 50-50 here, it looks significant here, with a range of maybe $500 million to $1 billion, give or take $500 million. I was a little bit more precise than that, but you get the point. And what happened about 3-4 nights in, we were in this big conference room, and I gave my series of lawyerly answers, and the managing director, the client, walked to the other end of this conference room, and he slammed his hand down on the table, and he said, "Eric," in a very, very stern manner, if we could quantify the litigation risk, maybe I could do something with it. I would love to tell you that right then and there, I had the light bulb moment, an epiphany that says what the client was suggesting could forever transform the way certain litigations are handled. But I didn't. Instead, I shrugged my shoulders and I said, we'll do our best. And I walked out of the room with two predominant thoughts. One, litigation risk cannot be reliably quantified. And two, even if it could, I had grave doubts that anything could be done with it. How very, very wrong I was. When we started looking into it, we actually found out that this practice, or one very similar to it, has been going on for at least the last 30 years. And it's a strategy that was perfected by someone you won't be surprised at, and that's Warren Buffett and Ajit Jain at Gen Re. And what they did, starting in the early 80s, and they continued to do, is they're buying insurance companies in runoff that have litigation risks in them. And they don't have to be as precise on their quantifications because they have something called float that they can use in these deals. So they've never had to be as precise. But the practice itself, as I said, has been around for quite a while. And when I discovered that, I also discovered an article that was written in the Chicago Law Review. And it was written by a professor, Malo, who Sylvia will tell you, co-founded Burford, in addition to being a professor at Georgetown. And what this article described, and it was called A Market in Litigation Risk, it was written about 10 years ago. And what it described were a series of scenarios where litigation could be bought and sold in a marketplace. And he hypothesized that the efficiencies necessary to achieve comfortable margins in that market would drive down the cost of litigation, something that he prominently noted that government reform has been unable to achieve. What he did in the article is he went through a series of potential obstacles to such a market. And he found achievable means of eclipsing all of them, except for one. Anyone want to guess what that one is? Price. So what becomes apparent is that if litigation can be reliably priced, it can be put in the hands of those who are only concerned with the bottom line. And that's really important because the thing that makes law or litigation so inefficient in large measure is the emotions that the litigants bring to the litigation. So I've always been interested in trying to figure out ways to strip emotion from that litigation equation. And this is a sure way to do it because if you put these litigations in the hands of third parties who don't care about the reputation, don't care about anything other than the bottom line, they're going to be able to implement efficient processes so that they can run off the risk for less than what it was worth to the actual seller. So this has completely transformed my practice. I used to be a traditional litigator, litigated all sorts of cases all over the country. But now what I do is I spend most of my time going into M&A situations and assessing and quantifying litigation risk of an acquisition target in order to, at least in the first instance, get a price reduction on that litigation risk. Any of you transactional lawyers out there know that in a deal, every single litigation is, or every single risk is assessed. And in most cases, it's quantified. Litigation risk is hardly ever quantified within a transaction. It only gets done when the litigation risk is so significant that it's a major part of the deal. But it should be treated like any other risk, and it should be analyzed and it should be quantified so that you can actually have a fair negotiation. But that's not the best part of this business. The best part of the business is after you negotiate that price reduction and you've closed the deal and you've then acquired that risk, you can then go out and sell that risk, box it, sell it to a third party for less than what you got on the price reduction. That is an arbitrage. That means that just by your client obtaining the risk and then turning around and selling it, they've made money. For a private equity play, that's exactly what they want to do. They want to strip the bad stuff out of these companies before they exit, before they sell them. So it's a very attractive, option for those who have, significant litigation risk or those who are acquiring other companies with significant litigation risk. The way in which we quantify these risks is not as hard as some of the criticisms that have been levied today about the inadequacies of what we do. Well, most of the litigation risks that I quantify, with the help of others, are repetitive mass claims in several different areas. And we have, as was pointed out by Jim, lots of data on that. We may not be able to get our hands on it all the time, but that data is out there. It's in insurance companies, it's in the actual defendants' databases. They may not be able to harness it, but it's there. And I always knew it was there, and I always knew it wasn't being used. But what I learned when I kind of started this journey about 5 years ago is that this was the advent of big data and data mining, and so that we finally have the tools to make sense of this data, to clean it, to pre-process it, to extract the important information out of it so that we can develop robust analytics to go into the modeling. That's what's important here. And anyone who thinks that you can't quantify, a mass litigation they'll sell you a bridge too, because you can. And lots of people have been doing it for a long time. And with data mining, it just gets that much better. Now, I agree with the one-off cases, it's much more difficult, much, much more difficult. But the analytics are getting to a point where I think it is going to become easier. What we can do is we can build these same tree diagrams and use objective data, outcome data that is available now, at least for federal judges. I mean, think about it. What we're able to do now, at least in federal courts, is we're able to tell you the likelihood that a particular judge will rule in a specified manner on a particular issue. Have you ever been able to do that? How many times did your client ask you, what the chances are that I'm going to win this case or win this motion to dismiss? So it provides you with information to give to your client, but it also gives you valuable information to actually model these risks. In conclusion, I think I only have 1 minute here. I look forward to a full discussion. NLP is not where we need it to be. The analytics that are in existence need to become more robust, but we're on our way, and we're already creating this market, and happy to answer any questions. Thank you.
Thanks. So I'd like to open it up to questions from the audience. We have about 15 minutes for your questions. Sullivan, we'll start with you. Just wait a second to get a microphone, if you don't mind.
Thank you. Eric, I couldn't agree with you more that this is measurable, the risk involved, at least to a far greater degree than people think it is. And one of the things which the industry, let me back up. The risk analysis governs the price analysis, because if you can figure out the risk, you can measure a price. And I think our industry, Andrew, that is the litigation finance industry, is, at least when I was in it, we oppose too much measurement of risk, because part of our pricing is that give us a lot of money because it's so much risk. And therefore, I think the greater the measurement of the risk, the better off the industry will be, and the better off the market will be in terms of buying and selling risk. And it gets back to, in a way, back to you, Mark. What do you think? What's your track record in determining the likelihood of winning or losing?
Well, of course, I don't I have a great job because I don't personally assign the probabilities. the lawyers that have been handling the case for however long they've been handling it are the ones that I grill, and in order to decide what the tree should look like and what the probabilities are, I'm bringing the discipline in the process so that they end up with something that does eventually fit their gut, that they feel comfortable with. And somebody who made the comment about the praise they got based on reserve pricing? Michael was making a comment to me over breakfast today, and I had a client who was involved in $1 billion arbitration, and we valued it in the X hundreds of millions of dollars, and the award came down within like 1% of the expected value of the case, which I said, well, that's fortuitous, but we had a whole range, we had that whole distribution, and it was a one-off case, and we could have ended up anywhere in the range, but boy did the client, the law department was getting pats on the back all over, and I said, now you remember I taught you this, because I do seminars and work on cases, and they say, yeah, we know, but it still feels really good. So what happens is companies that have used decision tree analysis a lot find that if they stray from it, they get more surprises. They're just getting too many surprises. And the more they use the decision tree analysis, not every case ends up at the expected value by any means, but they're not getting big surprises.
What the idea is at the portfolio level you would do, right? I mean,
no, I'm saying on individual cases, they're not getting big surprises. They're getting results that end up within the parameters of the tree. It's one of the paths on the tree. And the frequency then on a portfolio basis of being on the low probability things is low.
yeah.
And on the higher probability results is high. And David has a colleague who, when he was at general counsel of a different company, actually did keep statistics. So it's an old article, a short article, when he was at US West. So at Mass Mutual now, was at US West.
Mark, right?
Yeah, Mark Rolig. And he kept statistics of doing decision trees within the department for, I don't know if it was a year or something, but he wrote it up. And it was like 20% reductions in settlements and judgments and 40% in costs and so on. So most companies are afraid to do it. I know I'm spending a lot of time on the answer, but how many of you have, in insurance companies especially, have ever kept track of, here's what we assess as the chance of winning a motion or winning a whole case if it ends up going to trial, but even winning motions, or keeping something out in discovery, getting something in, and then written down the results when they happen 6 months or 9 months later, kept track of that for a year to look back and see how good are you at predicting what's going to happen.
So
A few people do, but yeah, well, I'm saying most lawyers and most companies have never done that. They're afraid to do it. It's a scary thought.
Jonah.
So my question, I guess, is for Eric and Dan, I suppose. For MDLs or auto accidents, stuff that happens a lot, you alluded to this in your remarks, Eric, it seems totally reasonable to me that we can figure out, that somebody can use data on existing things to figure out what are the odds that such and such an outcome happens. I think there may be some issues to talk about in terms of strategic behavior that I'll get into when I'm on the panel later. But leaving that aside, what I'm sort of interested to hear the two of you talk about is tail risk. So if you think about extreme values, extremely low probability events that are extremely bad, for instance, it strikes me that the 500-year flood problem is a really hard one for an innovative firm or a firm that says, we can do this because we've been doing it for 5 years or 10 or even 20, maybe even 100. And so I wonder how much you think about that kind of problem, I guess both analytically and in a more practical sense, maybe with Chapter 7 looming over you in the background. So. Want to go?
Well, I mean, you know, the adage, right? You don't know it's a 100-year flood till a 100-year flood happens, or a 500-year flood. So there is this tail risk. I mean, this is the case for selling the stuff in the first place, right? Is that I'll make it his problem on that tail risk with his method versus the alternative. The challenge is, I guess, a choice is to be made on some basis. I think that's sort of this, like, do we do analytics or not sort of conversation. A choice is to be made. So I can let the human be the computer, or I can use a machine or a combination thereof, right?
My question is, what makes you so confident? If some of the risks that you're going to care a lot about, or that your customers care a lot about, are extreme value risks, what makes you so confident that the methodology you're talking about is necessarily?
You don't know it's a 500-year, 250-year flood till you have it. So, but the point is that that problem exists whether you bring a human as like a subject matter expert and or a method, a model or method, right? That doesn't go away. I just think that we can do a better job at a larger end of surfacing those, but it's certainly the case that just like lots of things, you have a black swan event and you just don't know it's a thing. And there's no methodology to really deal with that. I mean, that's what reinsurance, for example, is for, right? And that.
Right? They have the same problem.
That's right. They have the same problem, but the idea they hope is that they've properly assessed the probability space, but there's no real answer to that. I mean, it's something one ought to be cognizant of completely. I totally accept that.
I think that is a cabining of the claims about what predictive analytics.
Yeah, absolutely, it's absolutely. I mean, please don't misunderstand me. But again, that problem exists no matter what method, humans or machines or mixtures thereof. I don't know, Eric, if you have.
No, but there's an argument to be made that the machines can do a better job even at that, because when you're talking about human experience, you're talking about someone who has a half a dozen experiences with possibly that flood that might happen in another area, so that they can give you some insight as to whether it's going to happen soon in another area. That's not very valuable at all. What would be valuable is if you have 20 years worth of data, even if that 100-year, 500-year flood doesn't happen, at least you have some 20 years of information to look back on to assess whether that's a likelihood. I don't have to worry about it as much, because what I'm assessing and what I'm quantifying are mass litigation. So I get to use the law of large numbers to my advantage, and I really need to do that because we do have those outliers. But we can usually capture it and still come within our threshold.
Are there any other questions, maybe from a student, before I use my prerogative as moderator to step in? My students, you have no questions? All right. I'm going to ask a question, then I'm going to call on one of you. So my question relates to something that we discussed on the phone, but we haven't had a chance in this forum to talk about, which is I've noticed a real rise in litigation analytic products that are available. So if you go on Bloomberg Law, they're trying to sell you stuff. Lex Machina was a product that that had come up, and I was wondering if you could give us your sense of what's going on in that space and what your evaluation is of those kind of products and how useful you think they are. And I'm going to call on Dan first.
Yeah, and I guess I would completely agree with Andrew in the sense, just from earlier, right, is that a lot of what you see in the market is people selling essentially averages as a service, right? What's the average of this? If you don't know the average, somebody tells you the average, that's a useful thing, but I wouldn't use it as a basis to bet real money, right? I mean, again, if it's a piece of information, it helps you make a better decision, good, but it's not the quality of what you'd see, say, in proprietary trading, which I think is really the arc you'll see here is people will take these data feeds like they do in prop trading, they roll them together with their own secret sauce, and that you were kind of sketching what almost sounds like that. And maybe it's human experts, maybe it's models, but you don't just take some third party's view of like what the probability of something happening is. You might take a data feed from them and then say, we're going to do our own brew. And again, now if you look in financial services, Bloomberg sells data feeds, Thomson Reuters sells data feeds. And I think that you'll see sort of more of that. But I think a lot of the products are pitched at, I'm going to tell you the average of something. And again, if that never existed, you didn't even have that visibility in, that was a useful thing, but I wouldn't go and bet my own money on the basis of something like that. So that's my own 2 cents. I don't know if others. I mean, that's kind of what I think you were.
Yeah, I
alluding to
agree.
earlier,
Yeah.
right?
I mean, when I was talking about how we use big data, right now, there are products available that aggregate publicly available data in ways that, or even some prop data, that was not available before, 10, 20 years ago. So that is a step forward. But then when they take the next step of, okay, here's a bunch of data and we've concluded some things about it, those are conclusions upon which we do not rely. Because first of all, we have a brand and people rely on our expertise, not some expertise of a third party provider. And so that would be a problem. But also we don't know what they're doing. I was really interested when you say, you can start, once natural language processing gets to the point where you can scan through 8Ks, 10Ks and discover trends in litigation, that would be, identifying trends, aggregating data, doing the work that is hard to do individually, trolling through databases. That is somewhere where I think products are, starting to happen, and there's starting to be more there. But right now, what we see is, 20 different ways of taking Pacer and turning it into something more easy to use, which is also extremely valuable, but not quite the same thing.
Yeah.
Right. Yeah, I agree with all those comments. Lex Machina in particular is not something that you'd want to rely on in modeling right now, at least not as your final model. You might want to use it to do a gut check on your experts, but it's just not robust enough at this point. However, what I'd say is that Lex Machina and the platforms that are using dockets and are crawling the dockets, I think, have the right idea. It's a new way of looking at a case judge specific and determining what issues have been before that judge in the past so that you can tailor arguments to the judge's propensities. And right now, what Lex Machina is relying upon, and several of these services are relying upon, is not natural language processing, but rather the coding that is already on the blurbs of Pacer. So all they're really searching is those blurbs that you see, not the underlying documents. And a lot of times you need to look at the underlying documents to find out what the outcome was, what the variables were that led to that particular decision. We'll get there, but natural language processing is going to be the answer. And the other answer is, or the other problem is we need to get our hands on the data so we can actually OCR it. Right now, we can't search it unless we buy it from Pacer. And I think Stanford, the Codex guys, estimated that buying the whole Pacer database would be at about $1.5 billion right now.
Pass the hat.
Yeah, right. But what I'm interested in is the academic push to get that to be an open source data source, because we can all benefit from it.
Can I just say one other thing? I just want, the difference between those products is if you would test this stuff out of sample with a model. And that's what, like, if you were going to bring a machine learning model in, you would say, I'm going to hold a set out, I'm going to test, build a model on that, and then I'm going to prove that I can, at least on my historic data, at least get sort of the same sets of outcomes that I would have gotten maybe with my experts or better. And that would be like the minimum before you would be willing to deploy it going forward. And again, that's just like trading. They back test the model against historic data, try to show that it would work on historic data, then you deploy it in real life. And that's the difference between the products and like what I think useful, what people want to really do.
So I think we have to close because it's, I have it at 12:45, is that right? Yeah, so I'm sorry for those of you who didn't get to ask your questions, but the panel will be here in the break. We have a 15-minute break, and then we'll resume for the final panel, and after that will be lunch. So if you need the brain food.